Madam President.
The senator from Iowa.
Madam President, I ask unanimous consent that Senators Graham, Gillibrand, Schumer, and I be able to complete our remarks prior to the vote on H.R. 4445.
Without objection.
Thank you, Madam President. Madam President, I also ask unanimous consent to engage in a colloquy with my colleague, Senator Graham.
Without objection.
Thank you, Madam President. Madam President, protecting survivors of sexual assault and harassment has been one of my top priorities here in the Senate. In fact, yesterday I introduced the Bipartisan Violence Against Women Act, Authorization Act of 2022, which now has the support of 10 of my Republican colleagues. Today, we're here to talk about another issue that is impacting too many in our nation's workforce. The Ending Forced Arbitration and Sexual Harassment Act of 2022 provides survivors of sexual assault and sexual harassment with a choice between litigation and arbitration, so their voices will not be silenced. Earlier this Congress, I was glad to see progress in the Senate Judiciary Committee as they move forward on this bill. The committee took action that I supported. They removed the provision on collective bargaining agreements. Just this week, I was even more encouraged when the House made further changes to the bill that improved the definition of sexual harassment. And while these changes are important and significant, it is still not a perfect solution. That is why when I sat down earlier this week with the Majority Leader and the lead Republican sponsor of this bill, my friend from South Carolina, we agreed to come to the floor and ensure the congressional intent of the Ending Forced Arbitration and Sexual Harassment Act of 2022 is crystal clear. During our meeting, my colleagues agreed with me that this bill should not be the catalyst for destroying pre-dispute arbitration agreements in all employment matters. Specifically, we agreed that harassment or assault claims should not be joined to an employment claim without a key nexus. Harassment and assault allegations are very serious and should stand on their own. The language of this bill should be narrowly interpreted. It should not be used as a mechanism to move employment claims that are unrelated to these important issues out of the current system. These clarifications are needed. I care very much and support survivors of sexual harassment and assault having access to the appropriate process to ensure swift justice. But it's also very important to me that those claims stand separate from any other kind of claim, and I'm grateful that Senators Schumer and Graham stand with me today in knowing that those claims are meaningfully different. There is one other important piece here that I would like to mention, and that I hope my colleagues can agree with me on. If an employment agreement contains a pre-dispute arbitration clause and a sexual assault or harassment claim is brought forward in conjunction with another employment claim, and the assault or harassment claim is later dismissed, a court should remand the other claim back to the arbitration system under this bill. I think we can all agree that we want to ensure survivors of sexual assault have their voices heard. We just have to do this in a thorough and thoughtful way. My hope is that the legislative intent of this bill reflects the conversation with my colleagues discussed here today. Namely, the Ending Forced Arbitration and Sexual Harassment Act of 2022 should not effectively destroy arbitration in employment litigation. This bill is narrow and scoped to address sexual assault and sexual harassment cases. These clarifications we are making here reflect the specific challenges that victims of these particular allegations face. And if any subsequent litigation manipulates the text to game the system, Senators Schumer and Graham have pledged to work with me on a bipartisan bill to further codify the intent and language of this bill. And I would yield to Senators Graham for further discussion.
Number one.
The senator from South Carolina is recognized.
Thank you very much, Mr. President. I agree with everything you said. You said it well. So what's the goal here? Senator Gillibrand and myself and many others have been working to stop the practice of someone signing an employment contract, having a sexual harassment or assault problem in the workplace and be forced into arbitration that's skewed for the employer against the employee for these things to be hidden. We do not intend to take unrelated claims out of the contract. So what we're preventing here is sexual assault and sexual harassment claims being forced into arbitration, which perpetuates the problem. The light of day of a courtroom is what we're hoping for. The plaintiff still has to prove their case. The defendant has robust due process. But Senator Ernst's concerns, I share. If lawyers try to game the system, they're acting in bad faith. They could be subject to disciplinary proceedings by courts. So what we're not going to do is take unrelated claims out of the arbitration contract. So if you got an hour and wage dispute with the employer, you make a sexual harassment, sexual assault claim, the hour and wage dispute stays under arbitration unless it's related. That's the goal. And I hope people won't game the system. I hope it will bring about the reform we're all hoping for to make it harder to hide these problems in the workplace, easier to get justice without gaming the system.
Senator from New York is recognized.
I just want to thank my colleagues, Senator Graham and Senator Ernst, for their outstanding work in this regard. We've worked over many years to get a bill that can be agreed upon. Senator Ernst made sure that her concerns were met in several ways. But I agree with both of their statements. I do not believe that survivors of sexual assault and harassment will abuse the ability to file cases in court. And the bill plainly reads, which is very relevant for Senator Ernst's concerns, reads that only disputes that relate to sexual assault or harassment conduct can escape the forced arbitration clauses. That relate to is in the text. The language of the bill specifically states that, quote, the term sexual harassment dispute means a dispute relating to conduct that is alleged to constitute sexual harassment under applicable federal, tribal, and state law. And, quote, the term sexual assault dispute means a dispute involving a non-consensual sexual act or sexual conduct. To be clear, there are no new legal burdens to sexual harassment established in the bill. It's all tied to, this was another concern that Senator Ernst had, it's all tied to existing federal, state, and tribal law. So this bill will basically give survivors the ability to go to court when they are, quote, alleging conduct constituting a sexual harassment dispute or a sexual assault dispute. When a sexual assault or sexual harassment survivor files a court case in order to seek accountability, her single case may include multiple claims. But as Senator Ernst said, if those claims on harassment and assault are dismissed, then she would go back to the arbitration process. But it is, and this is important to Senator Graham and I, it's essential that all the claims related to the sexual assault or harassment can be adjudicated at one time for the specific purpose that Senator Ernst is well aware of. We don't want to have to make a sexual assault or harassment victim relive that experience in multiple jurisdictions. So we want to be able to deal with all the harassment and assault related claims in one go. But again, if those aren't part of it, then this bill does not apply to it. So you are quite right in your clarification, and that is exactly how we intended the bill to do. Every state and federal court in the country requires a person to allege certain things in a certain way in order to properly plead a case, such that it won't be immediately dismissed. And victims here must follow the rules and plead a case correctly, and then they must also affirm to the court that they have a good faith basis for doing so. Attorneys must do the same thing. If victims and attorneys break those rules, they can be sanctioned in court, as Senator Graham mentioned. To ensure that a victim is able to realize the rights and protections intended to be restored to her by this legislation, all of the related claims will proceed together. I yield back to my colleagues. Oh, and can I give my, but I just read my full statement now? Sure. Do you have more to say, Senator Ernst? Thank you. Mr. President, I just want to, for the record, talk about this legislation and how important it is. I'm extremely grateful for the work of Senator Graham over the last 5 years in writing this bill, and I'm very grateful to the Majority Leader for meeting with Senator Ernst and Senator Graham yesterday to make the final decisions on this bill and to close the deal. Senator Schumer is one of the greatest listeners and has the ability to bring legislation to fruition, and that's exactly what he did yesterday, and I'm very grateful. This bill represents one of the most significant workplace reforms in American history. It will help us fix a broken system that protects perpetrators and corporations and end the days of silencing survivors. Too often, when survivors of sexual assault or harassment in the workplace come forward, they are told that they are legally forbidden to sue their employer because somewhere buried in their employment contract was a forced arbitration clause, often accompanied by a non-disclosure agreement. Instead of being allowed their day in court, these survivors are pushed into a system designed by the same corporation that they are challenging. They're blocked from seeking information that could prove their case, and they are left in the hands of an extrajudicial arbitrator who is typically selected by their employer and is not always a trained lawyer. The arbitration process not only allows the corporations to hide sexual harassment and assault cases in this secretive and often biased process, but it shields those who've committed serious misconduct from the public eye. Across the board, employees are less likely to win in arbitration than they are in court. Even when they do win, they typically receive much lower monetary awards. And because of the results of arbitration are secret and binding, there's no chance for an appeal, and repeat offenders are often not held to account. Estimates suggest that more than 60 million Americans are subject to arbitration clauses. Many don't even know it because the clauses are hidden in the fine print. Forced arbitration clauses are especially common in female-dominated industries. The ACLU has reported that 57.6% of female workers are subject to this practice. It also especially prevalent in low-wage fields and industries with disproportionately high numbers of women of color. These clauses leave those women who often cannot afford to challenge their employers without recourse. But this affects women in every industry. A 2018 analysis of sexual harassment claims made on Wall Street found that in 30 years, just 17 women, 30 years, just 17 women won their claims before Wall Street's oversight body, and in most cases were dismissed or denied. So I want to share the stories of two survivors to illustrate how broken this system is. First is Laura Henry, who worked at a Kia dealership in Ohio where her boss sexually harassed her, touching her inappropriately, making inappropriate comments, bringing her inappropriate gifts. When she reported him, the company did a sham investigation and forced her into arbitration. She was only able to share her story because Congress issued her a subpoena. She should not have needed the protection of a congressional subpoena to speak out. And when she testified, quote, "The cycle of harassment will continue if you force women to be quiet and allow sexual harassers and the companies that allow them to hide behind arbitration agreements." The second story is about Ndawa Newton, and who was working for the vice president of legal affairs at the luxury good company LVMH, Moet Hennessy, Louis Vuitton, Inc. in New York, when she reported being sexually harassed and assaulted by a colleague. Even though she filed her sexual harassment case in a New York state court, the company moved to compel forced arbitration, and on the grounds that federal law supersedes New York state law that attempts to protect victims and harassment from being forced into operation, she said, quote, "Because of forced arbitration and confidentiality agreements, I may never know the extent to which this perpetrator sexually assaulted or harassed others, and if LVMH retaliated against others as they did me. His sexual harassment, attempted assault, and assault made me feel scared, demeaned, and ashamed. I found myself constantly agitated, distressed, and hypervigilant, preoccupied with avoiding the trauma of encountering him." Even with her legal expertise and experience as vice president of legal affairs, she was powerless in this system. She said the company convinced her, quote, that harassment was just a byproduct of being an attractive woman who works at a company with a French culture. That is the same company running the arbitration process. That's why this bill fixes the problem. Survivors deserve a real chance at justice, and that's what this bill does. This bipartisan, bicameral bill would amend the Federal Arbitration Act to void all forced arbitration provisions for sexual assault and harassment survivors. Removing those provisions would give survivors the day in court, allow them to discuss their case publicly, and end the days of institutional protection of harassers. This legislation passed with bipartisan, broad support in the House, and I hope my colleagues will join us in supporting this critical workplace reform in the Senate. Again, I thank Senator Schumer and Senator Graham. I yield the floor.
President, and first, let me
Majority Leader is recognized.
let me compliment my colleague from New York. Her persistence, her intelligence, her determination and passion to change the law so these injustices, which occur so many times that we don't know about, will no longer be there, is so vital. So thank you for a job well done. Thanks to my colleague, Senator Graham, the lead Republican sponsor, who, when he gets behind something, it gets done. So I want him behind more things with us in the future. And to Senator Ernst, who is not here, she's been a great leader on this as well. And when we met in my office, Senator Graham, Senator Ernst, she was very amenable to getting this done. It is an outrage, just an outrage, that women and men who are abused cannot seek justice, are forced to be quiet, are forced to keep the agony inside themselves. It's outrageous. For decades, this forced arbitration has just deprived millions of people, almost all women, from basic rights to justice. And we need justice in so many areas, but when you can't seek justice when you are harassed, it is just one of the greatest marks of injustice, one of the greatest times of injustice. And the good news about this legislation is all the clauses that people already signed in their employment contracts, even when they didn't know about it, will no longer be valid. So it not only affects the future, but affects those who signed in the past. If you could ever say that any legislation is long overdue, this is it. It's time for a change, and moments from now, the Senate will finally act to make forced arbitration for sexual harassment and assault a thing of the past. We are now going to voice vote this wonderful, needed legislation.
Mr. President?
Senator from South Carolina.
I'll be real quick. Senator Schumer, thank you for making this happen. You made sure it would come up today. We get a voice vote. Senator Ernst's been great. Kristen, it's been a hell of a ride. We talked to Microsoft about 3 or 4 years ago about this. They jumped on board and started changing it internally. I've heard from the chamber. I'm open-minded about making sure we don't hurt business. It does not hurt business to make sure that people who are harassed in the workplace get treated fairly. It's better for business. So I just want to say this shows that we can function up here, that we're listening to the world as it is. So the days of taking sexual harassment, sexual assault claims, and burying them in the basement of arbitration are over. Arbitration has its place between business. It can be a good thing, but when you sign a document, multiple pages, just to get a job, you really don't know what you're signing. We're saying you're not going to sign away your life in terms of having your day in court if somebody treats you poorly. You still got to prove your case. The defendant has robust due process rights, which they should, but the abuse of arbitration that perpetuates sexual harassment and sexual assault in the workplace is soon to be done away with. Thank you, Senator Schumer. Thank you, Senator Gillibrand. And to all of my colleagues on the Republican side, thank you. This is not bad for business. This is good for America.
Under the previous order, the clerk will read the title of the bill for the third time.
Calendar number 264, H.R. 4445, an act to amend Title IX of United States Code with respect to arbitration of disputes involving sexual assault and sexual harassment.
The question is on the passage of the bill. All in favor say aye.
Aye.
Opposed, nay. The aye appears to have it. The ayes do have it. The bill is passed.
Nomination, Federal Maritime Commission, Max